executive order, which was communicated by way of a signed press statement to forcefully claim ownership of the land parcel number LR 209 and thus 11157, thus forcefully evicting the managing agents of the petitioner's property and tenants in the KICC and altered the petitioner's office. That this takeover of the petitioner's property was without compensation or consideration to the petitioner, neither was the executive order produced nor served upon the petitioner to enable it to respond. The respondents, on the other hand, have it that the suit challenging the executive order that was issued on the 11th of February 2003 that enabled the government to take over the management of the suit property, which is miscellaneous civil application number 128 of 2003, was heard and determined in favor of the respondents. They also contended that the petitioner's acquisition of the suit property by respondents did not comply with the requisite provision of Chapter 12, which I already read. Although the respondents did not demonstrate that the notice was served to the petitioners informing them of the takeover, it is sufficed that the matter was already canvassed before a competent court of law and the court determined the matter. This court is of the view that although the petitioner has alleged that their rights under the Constitution were violated, they have not proved that the takeover of the suit property, which does not belong to them, was unlawful and that it has in any way interfered with the petitioner's right to property. This court has established that the petitioner is not the owner of the suit property, having acquired it in the most unprocedural of ways, which was annulity ab initio. Further, the bills being claimed to have accrued to the respondents were accrued by the petitioner, and the court made this finding already. Thus, the 6 respondents' action for demanding the settlement of the accrued utility bills is legal and right. Although the petitioner has alleged that they stand to suffer irreparable harm if the suit property in Nakuru Municipality Block 9/31 is sold, this, however, will be in compliance with the court order of 12th of February 2015, following the judgment of Judge Receipt as she then was. This court has established from the evidence on record that the suit property belongs to the government as the cross petition states. The petitioner, in their submission, stated that the property belongs to their petitioner, and in the event that the government has acquired the property forcefully by evicting the petitioner, then this has been done against the doctrine of compulsory acquisition. And therefore, the petitioner should be compensated as already required by the law. I am of the view that the petitioner is not entitled to any compensation, as the building erected on the suit property was erected by the government using public funds. It is a public building, and I've also established that the suit property belongs to the government as claimed by the first to the 4th cross petitioners. And there's no way the petitioner will be compensated by the doctrine of compulsory acquisition. This court is of the view that in situations like this, the government should indeed have clear procedures on taking over government properties which are in the hands of private entities illegally, so as to avoid parties coming to court to seek for compensation and damages. Finally, whether the cross petition is merited. The 1st to the 4th respondents in the cross petition allege that the suit property is public land and that the development of the suit property was, which is KICC, was funded by the Exchequer, project number 530-801A-001W at a cost of British pounds 3,987,350, registered as the government building number Nairobi, /admin, /38/1. It is the registered owner of the property. The cross petitioners allege that the suit property being claimed by the petition was obtained and acquired in breach of Article 62, which provide the manner in which public land shall be disposed of. Further, that the suit property houses KICC, which as they testified was constructed using public funds. In the case of Paul Nderitu Ndongo and 20 others versus Pashito Holdings Limited and another, Commission of Lands had no legal authority to allocate the 2 pieces of land which had been reserved for a police post and a water reservoir, as they had already been alienated. In the case Paul Nderito Ndongo case, Musaga Mbogoli, as he then was, stated as follows: under the Government Land Act, the Commissioner of Lands can only make grants or dispositions of any estates, interests, or rights over unalienated government land, as provided for under Section 3 of the GLA, now repealed. In the instant case, the 2 parcels of land, among others, had been alienated and designated for particular purposes. It was not open for the Commissioner of Lands to re-alienate the same. So the alienation was void ab initio. In another case, Henry Modem Katurima versus Commissioner of Lands, the court also stated as follows: the Commissioner of Lands had no power to alienate public land, and any action taken without due authorization is a nullity. And they cited the case of Said bin Said versus Sharif Mohammed in that case, and reiterated that an action taken by the Commissioner of Lands without legal authority is a nullity. Such an action, however, is, though technically correct, is a mere nullity. That's what the court stated. The cross petitioners have been able to specifically prove the particulars of breaches of clearly laid down procedures in law that were not followed by the petitioner in seeking to acquire the property. The suit parcel public land, the petitioner ought to have followed the procedure provided in law in order to have the suit land allocated to them if they wanted to do so. This court has looked into the evidence on record, and it's clear that the suit parcel was illegally, unprocedurally, and unlawfully acquired by the petitioner. And now the disposal orders. This court finds that the petitioner's petition is unmerited and is hereby dismissed with costs. The cross petition filed by the first to the fourth respondents is merited, and this court therefore orders as follows. 1. A declaration is hereby issued that LR 209/11157 was obtained illegally, unlawfully, and procedurally, and without following legal procedure, and hence nullity ab initio. 2. That the title documents and leasehold interest created in LR number 209/11157 is illegal and confers no interest to the first petitioner respondent per the provisions of Article 46 of the Constitution. 3. That the allocation of the suit property to the first respondent without following the legal procedure is unlawful, that the allocation of the suit property to the first respondent without following the legal procedures is unlawful, illegal, and unconstitutional. 4. That the title for LR number 209/11157 in the name of the first respondent with the cross petition is hereby revoked. 5. That the suit property as registered being LR 209/19829 issued in the name of the Permanent Secretary to Treasury to hold in trust for the Ministry of Tourism is lawful, is legal, and constitutionally appropriate title for the suit property. 6. A declaration is hereby issued that the Ministry of Tourism is the lawful owner of the suit land LR 209/19829, and the first respondent's registration of LR 209/1157 is unlawful, illegal, and it's unconstitutional. 7. This being a public interest case, I will direct that each party will bear their own cost of the cross petition and the petition. Those are the orders of this court. Are you in this matter.